A major suppressor freedom measure has just cleared its final hurdle, and the impact could ripple far beyond a single state. In a decisive vote, lawmakers moved to strike down their state-level mirror of the National Firearms Act suppressor restrictions, removing suppressors from their controlled weapons statute and ending state enforcement of federal NFA rules. This is not a symbolic resolution. This is statutory change. For decades, suppressors have occupied a strange legal gray zone. Federally, they've been regulated under the National Firearms Act, requiring registration, background checks, approval processes, and historically a $200 tax stamp. At the state level, many legislatures went further by criminalizing suppressor possession under their own controlled weapons laws, creating a dual-layer enforcement system. That's what just changed. The newly passed Suppressor Freedom measure removes suppressors from the state's definition of prohibited or controlled weapons. In plain language, the state will no longer charge someone solely for possessing a suppressor under state law. That authority disappears. And that's enormous. Because here's what most people don't realize. Federal enforcement of NFA regulations has always relied heavily on state cooperation. When local law enforcement encounters a suppressor during a traffic stop, a domestic call, or an unrelated investigation, state law has traditionally allowed immediate arrest under state statute, even before federal agents get involved. Without that state statute, that enforcement pathway collapses. Let's break down exactly what just happened. First, the bill removes suppressors from the state criminal code's controlled weapons section. That means no standalone state felony for suppressor possession, no state-level prosecution layered on top of federal charges, no parallel state penalties. Second, it explicitly affirms that state and local officials are not obligated to enforce federal NFA suppressor provisions. This invokes the constitutional doctrine established in Prince v. United States, where the Supreme Court ruled that the federal government cannot compel state officers to enforce federal regulatory programs. This principle, often referred to as anti-commandeering, is critical. States cannot block federal law, but they are under no obligation to assist it. And that's the lever this legislation pulls. By removing state-level criminalization and declining to participate in enforcement, the state has created what legal analysts call a non-cooperation environment. Federal law still exists. Federal agents can still enforce it, but the multiplier effect of thousands of state and local officers acting as de facto federal enforcement arms, that's gone. To understand why this matters, consider scale. There are roughly 2,500 to 3,000 ATF agents nationwide. That's fewer agents than many single metropolitan police departments. Historically, federal NFA cases often began with state-level encounters, not independent federal investigations. If suppressor possession is no longer a state crime, officers have no state charge to file. That means no automatic state arrest, no state holding charges, no stacked penalties. Federal agents would have to independently build and pursue the case. That changes the calculus entirely. Now let's talk about the political dimension. This measure passed with strong support, not by a razor-thin margin, but decisively. That signals something important. Lawmakers are increasingly viewing suppressor regulation not as a public safety necessity, but as a federal regulatory burden that states don't need to replicate. And they're looking at data. According to federal crime statistics, suppressors are involved in an extremely small percentage of gun-related crimes, often so small they barely register statistically. Meanwhile, suppressor ownership has increased dramatically over the past decade due to processing reforms and tax changes. In 2023, Congress reduced the NFA tax stamp cost for suppressors to $0 through budget reconciliation. That move fundamentally altered the original tax-based justification for the law. The NFA had long been upheld as a constitutional exercise of Congress's taxing power. With the tax removed, legal scholars have begun debating whether that foundation still stands. And that's where this story gets even bigger, because this state-level repeal doesn't exist in isolation. It's happening in the shadow of major Second Amendment litigation following the Supreme Court decision in New York State Rifle and Pistol Association versus Bruin. In Bruin, the court established that firearm regulations must be consistent with historical tradition, not justified through modern balancing tests. That text and history framework has already reshaped lower court rulings across the country. Suppressors did not exist in 1791 when the Second Amendment was ratified. They were not historically banned. They were not subject to taxation schemes in the founding era. That absence is now central to multiple federal court challenges targeting NFA suppressor regulations. So what we're seeing is convergence, state-level non-cooperation, federal tax justification weakening, Supreme Court jurisprudence shifting toward historical analysis, and record numbers of suppressor applications being filed nationwide. This isn't just a state bill, it's part of a broader structural shift. Now, critics argue that removing state enforcement creates legal confusion, that citizens may mistakenly believe suppressors are entirely unregulated. That's an important clarification. Federal law still applies unless overturned by the courts or changed by Congress. But practically speaking, enforcement without state participation becomes exponentially harder. Think about how most cases originate. They began with routine encounters, not specialized federal operations. If local officers no longer have a state statute to rely on, the pipeline feeding federal prosecution shrinks dramatically. And that's not theoretical. In states that previously reduced NFA enforcement cooperation, federal prosecution rates declined significantly within 12 to 24 months. The reality is this. Enforcement capacity is finite. When states step back, federal agencies must prioritize, and suppressor-only technical violations often fall low on that list compared to violent crime or trafficking cases. This is how regulatory systems erode, not through a single sweeping repeal, but through strategic structural disengagement. Which brings us to the bigger question. Is this the beginning of a coordinated state-by-state unraveling of NFA suppressor enforcement, or is it a temporary political statement? That depends on what happens next, because several other legislatures are now watching closely. If this measure results in no measurable spike in crime, no public backlash, and no federal crackdown, momentum could accelerate. And if a federal appellate court strikes down suppressor provisions under Bruin's historical test, the entire national framework could shift overnight. For now, what's clear is this. A state has officially removed its mirror of NFA suppressor restrictions. State-level felony exposure is gone, state enforcement assistance is withdrawn, and the legal battlefield has moved decisively into federal courts. This isn't the end of the story. It may be the opening move of something much larger. Because what just happened at the state level doesn't exist in a vacuum. It's part of a broader strategy unfolding across multiple legislatures, one that legal scholars are quietly describing as a structural rollback of federal firearms enforcement capacity. This isn't nullification. It's not open defiance of federal authority. Instead, it's something far more methodical, non-cooperation. Under the anti-commandeering doctrine affirmed in Prince v. United States, the federal government cannot require states to enforce federal law. States cannot obstruct federal agents, but they also have no obligation to provide manpower, funding, jail space, or prosecutorial assistance. That distinction is subtle but powerful. When suppressors were listed as controlled weapons under state law, local officers had immediate authority to arrest and charge under state statute. Those cases frequently served as the entry point for federal involvement. The state would initiate the process, and federal agencies would decide whether to adopt the case. Remove the state charge, and the process changes entirely. Now, if a suppressor is discovered during a routine encounter, there's no automatic state-level offense. There's no guaranteed detention based solely on suppressor possession. And unless federal agents independently pursue the matter, it may never move forward. That's not speculation. That's how resource prioritization works in real life. Federal agencies operate with finite personnel and budgets. The Bureau of Alcohol, Tobacco, Firearms, and Explosives, commonly referred to as the ATF, employs only a few thousand agents nationwide. They are tasked with addressing trafficking networks, violent felons, explosives violations, interstate gun crime, and regulatory oversight. Standalone suppressor paperwork cases are not typically their highest priority. And this is where the numbers matter. In recent years, suppressor applications have surged dramatically, especially after Congress reduced the tax stamp cost to zero through reconciliation measures. That change fundamentally altered the financial barrier that once discouraged ownership under the National Firearms Act. Originally, the $200 tax in 1934 functioned as a de facto prohibition. Adjusted for inflation, that amount equaled several $1,000s in today's currency. It was designed to be financially restrictive. With that tax reduced to $0, suppressor registration has accelerated, processing volumes have increased. Approval times have fluctuated, and administrative strain has grown. But here's the key. As lawful ownership increases, enforcement complexity increases too. More suppressors in circulation means more interactions, more technical compliance issues, more inherited devices, more transfers, more paperwork variables. Now imagine layering that complexity onto a federal agency operating without consistent state cooperation. The enforcement model begins to thin out, and legislators understand this. By removing suppressors from state criminal codes, they are effectively saying, if the federal government wants to regulate this item, it can do so, but it will do so alone. That doesn't invalidate federal law, but it shifts the operational burden entirely upward. This strategy has historical precedent. Northern states in the 19th century declined to assist in enforcing federal fugitive slave laws. More recently, states across the political spectrum have declined to enforce federal marijuana prohibition. The mechanism is the same: refusal to allocate state resources. Over time, this creates political pressure, because laws that cannot be consistently enforced begin to lose legitimacy. Courts notice, legislators notice, voters notice. Now let's address the economic layer, because it's impossible to ignore. The suppressor industry has grown into a substantial manufacturing sector. Modern suppressors are precision-machined devices requiring advanced metallurgy, CNC equipment, engineering expertise, and quality control systems. They are not backyard products, they are industrial goods. As ownership increases, states recognize an opportunity. Manufacturing facilities create jobs. They generate payroll taxes, property taxes, and supplier networks. Tooling companies benefit. Logistics providers benefit. Small machine shops benefit. When a state removes suppressors from its controlled weapons list, it sends a signal. This industry is welcome here. That matters in competitive economic climates. States already compete for semiconductor plants, EV battery factories, and aerospace facilities. Firearms accessory manufacturing is simply another sector within that landscape. Opponents argue that easing restrictions could increase public risk. Supporters counter that suppressors primarily reduce noise. They do not make firearms silent, and they do not eliminate ballistic signatures. Sound suppression typically lowers gunshot decibel levels by 20 to 35 decibels. A suppressed rifle is still loud, often comparable to a jackhammer. The Hollywood silent assassin perception does not align with acoustic reality. That scientific gap has increasingly entered legislative debate. Some lawmakers frame suppressors as hearing protection tools. Others frame them as regulated firearm accessories. The framing shapes policy. And here's where the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin becomes pivotal again. Under Bruin's text and history test, courts must determine whether modern firearm regulations align with historical tradition. Governments must demonstrate that contemporary restrictions are analogous to regulations that existed during the founding era. Suppressors did not exist in 1791, nor were there taxation-based accessory registration schemes. This historical vacuum has opened a new legal front. Several federal lawsuits now challenge NFA suppressor regulations directly. Some argue that suppressors qualify as arms under the Second Amendment. Others argue that the registration and approval process constitutes unconstitutional prior restraint. Lower courts are divided. Appeals are pending. And that's the strategic timing here. State legislatures removing mirror restrictions are positioning themselves ahead of potential federal rulings. If a circuit court strikes down suppressor regulation under Bruin, states that already decriminalize possession won't need emergency legislative sessions to respond. They'll already be aligned. Conversely, states that maintain strict mirror statutes could face immediate constitutional challenges in their own courts. In other words, this is not reactive policymaking, it's anticipatory. And politically, it carries relatively low risk in certain regions. Suppressor reform does not poll like broader firearm deregulation debates. It does not dominate headlines the way magazine capacity or carry laws do. For many legislators, it represents a contained technical reform with symbolic federalism implications. But symbolism matters, because if multiple states adopt similar measures in rapid succession, the practical effect could resemble a patchwork softening of enforcement nationwide. Not through congressional repeal, not through executive order, but through cumulative non-cooperation. That's how structural systems change. Slowly at first, then all at once. And the final question looming over this development is simple. Will Congress respond? There are already proposals circulating to remove suppressors from NFA regulation entirely. None have advanced significantly yet. But legislative momentum often builds from state-level action. Federal lawmakers frequently cite state experimentation as justification for reform. The coming months will reveal whether this was a single state anomaly or the first domino in a larger chain. For now, one thing is certain. State-level NFA mirror enforcement has been struck down in this jurisdiction. Federal authority remains intact, but stands alone. And the legal, political, and practical consequences are just beginning to unfold. Because what makes this moment different from every previous attempt to roll back suppressor restrictions is not just politics, it's timing. For nearly 90 years, the National Firearms Act has survived constitutional scrutiny largely because courts treated it as a tax measure. In 1937, the Supreme Court upheld the NFA in United States versus Sonzinski, reasoning that Congress has broad authority to levy taxes, even if those taxes incidentally regulate behavior. That tax was the legal anchor. For decades, the argument was simple. This is not a ban, it's a tax and registration system. Pay the tax, file the paperwork, receive approval. But when Congress reduced the suppressor tax to $0, something subtle but significant changed. A tax of zero raises obvious questions. If revenue is no longer being generated, can the framework still rely on taxing authority? If the regulatory burden remains, but the tax vanishes, what is the constitutional basis for the scheme? That debate is no longer academic. It's unfolding in federal courtrooms right now. And layered on top of that debate is the Supreme Court's 2022 decision in New York State Rifle and Pistol Association versus Bruin. Bruin fundamentally altered the legal landscape by eliminating interest balancing in Second Amendment cases. Courts can no longer weigh modern policy concerns against constitutional text. Instead, they must examine historical tradition. That shift is seismic. Under Bruin, if a firearm regulation lacks historical precedent dating to the founding era, it faces serious vulnerability. The burden now rests on the government to show that modern restrictions are consistent with the nation's historical understanding of the right to keep and bear arms. Suppressors complicate that analysis. They are accessories, not firearms themselves, but they attach to firearms. Some legal scholars argue they are integral to the effective exercise of the right. Others argue they fall outside the core definition of arms. Federal courts are wrestling with that distinction. If a circuit court rules that suppressors qualify as protected arms or that the NFA's registration requirements lack historical analog, the case could move rapidly toward Supreme Court review. And the current court has shown skepticism toward expansive administrative regulation. This is why state-level decriminalization matters so much. If federal suppressor restrictions remain weakened or struck down, states that have already removed their mirror statutes are positioned seamlessly. There would be no conflict between state and federal law in those jurisdictions. But in states that still criminalize suppressors independently, immediate legal challenges would likely follow. In other words, this is chess, not checkers. State lawmakers are anticipating potential federal outcomes and aligning accordingly. Now, let's examine enforcement reality. Even if federal suppressor regulations remain intact for now, enforcement capacity remains finite. The ATF must prioritize violent crime, trafficking networks, explosives investigations, and interstate cases. Purely technical suppressor violations, especially absent other criminal conduct, fall lower on that spectrum. Without state cooperation, the volume of cases federal agents can independently pursue shrinks. That doesn't mean enforcement disappears. It means it narrows. And narrowing enforcement changes behavior. When citizens perceive that enforcement is inconsistent or rare, compliance patterns evolve. Applications may increase. Market demand may grow. Political pressure may intensify. We are already seeing record suppressor application volumes nationwide. Processing backlogs fluctuate. Approval timelines shift. Administrative strain becomes visible. Regulatory systems under strain often reach inflection points. At some point, policymakers must choose between expanding resources, reforming rules, or reducing regulatory scope. And Congress cannot ignore the economic dimension forever. Suppressor manufacturing is now a multi-state industrial sector. Facilities employ machinists, engineers, logistics coordinators, compliance officers, and quality assurance teams. Supply chains extend into metallurgy, aerospace tooling, coatings, and advanced materials. As more states remove mirror restrictions, the industry gains stability. Investment becomes safer. Expansion accelerates. That creates a feedback loop. Economic growth strengthens political influence, which strengthens legislative momentum. Opponents warn of normalization. Supporters argue normalization is the point. But here's the reality that transcends politics. Once regulatory regimes begin to fracture at the state level, while simultaneously facing constitutional challenge at the federal level, stability becomes difficult to maintain. Legal uncertainty alone can prompt reform. If appellate courts split on suppressor regulation under Bruin, the Supreme Court may feel compelled to resolve the conflict. If Congress sees mounting state divergence, legislative proposals may resurface with greater urgency. There are already bills introduced in prior sessions aimed at removing suppressors from NFA regulation entirely. They have stalled before, but legislative momentum is rarely linear. It builds in waves. That convergence has not existed simultaneously before. So what happens next? There are several possible paths. 1. Federal courts uphold the NFA suppressor framework despite Bruin, stabilizing the system temporarily. State non-cooperation continues, but federal authority remains intact. 2. A circuit court strikes down suppressor registration requirements. The Supreme Court grants review. A landmark decision reshapes federal firearms law. 3. Congress acts preemptively, either to codify reform or to reinforce regulatory authority. 4. A patchwork landscape persists, with some states fully disengaged and others doubling down, creating increasing interstate tension. Which path unfolds will depend on litigation outcomes, election cycles, and public response. But regardless of trajectory, this moment marks a turning point. A state has formally struck down its mirror of federal suppressor restrictions. State-level felony exposure for suppressor possession has ended there. State officials have withdrawn from assisting NFA enforcement, and the constitutional debate has intensified. For decades, suppressor regulation was treated as settled law, politically untouchable, legally stable, administratively routine. That era appears to be closing. We are entering a period of re-evaluation. Whether you support deregulation or oppose it, one fact is undeniable. The conversation has shifted from if to when. When will courts rule? When will Congress act? When will additional states follow? The trajectory suggests momentum, not stagnation, and momentum in law, especially constitutional law, can reshape institutions faster than anyone anticipates. This is not merely a policy tweak. It is a structural challenge to a 90-year-old regulatory framework, and it is unfolding in real time. That's where things stand right now. The Suppressor Freedom measure has cleared. State-level NFA rules have been struck down in this jurisdiction. Federal authority remains but stands alone, and the next chapter will likely be written in the courts. Stay tuned.